This Newsfile, this is your most authoritative news analysis platform. Today, get ready. We'll take you to the, if you like it, the Law Lecture Theatre, and you learn some good law. All of us need it. Now, my outfits, Konati clothing. And they say that Ramadan Kareem, and thank you for placing your orders, and they have made deliveries, and they are excited about your patronage. But they say after Iftar, is that last night or when, you still have the opportunity to call them and make your orders, and you get between 10 to 15% discount just for you. Call them 0244 676732, 0244 676732. Konati Clothing. They'll make you look good. My guest right here in the studio, Nana Ejay Bafo Ewa, MP, Menchia South. The last time he was on the show and I introduced him, there was no MP to his name. Congratulations. First time on the show after you won and came to Parliament. Good morning. And Victor Kojoga Adaudo, his member, legal team of the NDC, used to be a regular on Newsfile. It's been a long time.
Yes, I'm yeah.
Good to see you.
Rick.
Right. Amanda Akoko Clinton is head of Chambers, Clinton Consultancy. Thank you so much for making time to join us. I think late last year or early this year, you've been with us when we had to discuss another impeachment process, right?
Yes, I think that was late last year.
Great. Thank you very much. And joining us via Zoom, Dr. John Osai Kwapong, CDD Fellow. He will bring a governance perspective to the issues we will be discussing. And also the Honorable former Attorney General Minister for Justice, Ni Ayikwe Otu. He joins us via Zoom, and we'll do the first 15 minutes or so quickly with him for his take on the development so far before we take over from him in the studio. Thank you for joining us, Mr. Ayikwe Otu. Yes, please unmute your mic. You are on. Hello, Mr. Ayikwe Otu, you are on. Please unmute your mic.
Okay, can you hear me now?
Great. We hear you. It's fabulous. So, first about the CJ, who is, call it, under siege. 3 petitions, unprecedented. Normally it would be 1 petition or something of the sort for her removal. Let's begin from what becomes of the suits that have been filed in the Supreme Court and the pending injunction application to be moved on, Tuesday or Wednesday? What becomes of these processes now that the president has received consent from the Council of State and has forwarded the documents she was seeking and for which the suits were instituted, and she has 10 days to file her preliminary response? What becomes of those suits?
Well, thank you for your question. I think they have become moot. The Supreme Court does not exist, or any other court does not exist to give deal in academic matters. So if the real life issues were that the procedure had been truncated and had not been properly followed, and as usual, the press had interviewed so many lawyers who have brought in their perspective, and the president appears to have listened to those perspectives and therefore rectified what it was that was looking that bad, and for what people were rushing to court has now been rectified. If you say that indeed the issues, the petitions ought to be referred to you for your inputs before the Prima Facie determination, that has now been done. So clearly, I believe that those cases have become moot.
Right. Is it, from what you have heard from the presidency, is it really a matter of the presidency now listening and forwarding the petitions, or it is a case of a premature preemption on the part of both the plaintiffs in the suit and the Chief Justice, the Honorable Lady Chief Justice, who wrote to the presidency on the 27th asking for copies of these petitions?
Well, the Constitution guarantees the freedom of speech, and as you know, the press or the media exercise that freedom when these things appeared in the media. Yesterday, I was on one of your platforms, and I was saying that were those involved flying kites? Because they set up a panel for all of us, and we also who was going to be chairman, so and so and so. Again, even reading the law, they are not members of the committee. So what was all this? And the Chief Justice, I think, was right in saying that she has also read from the media the things that are going on. And if the thing concerns her, then she cannot keep mute. So I think the media somehow created the brouhaha by saying that the committee has already been set up and they are about to embark on the preliminary investigations.
I'm not sure there was any report about a committee being set up. The presidency's communication was that the president had forwarded the petitions to the Council of State for consultation, pursuant to Article 146, Clause 6, which commands the president to consult with the Council of State in determining, not really in determining, okay, let's say because of a J-Chum, to determine a Prima Facie before the committee will be set up. So therein comes the question that they wrote to the Council of State on the 24th. And the Council of State wrote back consenting to the president. They wrote to the Council of State actually asking and seeking consent that they were to commence the process. And if the Council of State would approve, they would forward the processes to the Chief Justice. The very day the Chief Justice wrote is the very day we are told that the Council of State wrote back giving the consent. And then the next day, it is forwarded to the Chief Justice.
Samson, I'm aware, you are very, very much aware about fake news. I think it's been one of your takes before. So I believe there was a lot of fake news all over the place about the committee having been set up with the former Chief Justice of Akufu, Betimo, Idrisu, all kinds of names. And these were flying all over the place.
Sofa Akufu is member of the Council of State. Betimo Idrisu is member of the Council of State. They are disqualified from being members.
I'm saying so. And yet these news items were all over the place. The committee, a 5-member committee has been set up with herself and the Betimo, people who are even supposed to be members of the Council of State. So I am not surprised. I mean, were you not in this country when we heard that Senator Rawlings had already been given a post, only for Facie to come out to say that nothing of the sort exists. Okay. And they were all on government letterhead, Office of the President, announcing appointments. They turned out not to be true.
Okay.
You get my drift. So I think fake news fed into everything, and then it made people to become a little jittery about it.
The president said he was... The president said he was disappointed in the Chief Justice for publicizing her letter to, the council and to him and the council and also copying, persons or entities who were not supposed to be part of this in-camera process. The law says the process, all proceedings must be in camera. So if you copy people who are not part of this process, you are rather, breaching the in-camera rule. What do you say?
Well, she was only asking for copies of the petition to be given to him. What I understand the law to be saying is that the petition should never come into the public domain because people respect the judiciary, and if you scandalize the judiciary on points which are not true, only for them to turn out to be untrue indeed, then people might have formed impressions about the judiciary already. So do not publish the petition. I don't think that was what she was doing. She was only asking that copies be sent to her.
All right. So this debate about Prima Facie, Is the CJ entitled to a prima facie determination, entitled to be asked to bring a comment or response for the prima facie determination? And when should that actually happen?
Well, if you have not heard the view of the person you are going to investigate, what kind of investigations are you going to set up for yourself? It's only fair that you hear from both sides and then try to find out where is the prima facie case. I mean, perhaps the person who is filing this petition may not have insights into the allegations that is making against the Chief Justice that maybe is authorized by the Constitution or by any other law to act in a certain manner. And then he believes that the act itself amounts to a stated misbehavior or something. Again, the rules are quite clear that the justice of the Superior Court or a chairman of the regional shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body or mind. This is the golden rule. This is the standard that you are to follow. So whatever it is that somebody is saying, let me also find out whether in fact he has brought evidence to show that I have misbehaved in a certain manner, I'm incompetent in a certain manner, or although I'm fit, well, and kicking, I'm still not that well as a result of infirmity of body or mind. So if you don't show these things to me for me to respond, how would you then make a determination that the prima facie case has been made against me? And it's not only that, but the Ajetrum and the Tiger Eye Dairy cases all point to saying the same thing. That it's only fair. I mean, it's like saying common sense arising from natural justice that you're going to make a decision against somebody. That person is entitled to be heard. And just show me the petition. Let me see what the people are saying. Let me respond to them. That when I did this because I'm authorized by law as the head of the judiciary to take a certain step. And that is all I did in accordance with the Constitution. It's like saying you should not empanel the panel that would hear the matter because you are interested. And the law is that whether you are interested or not, it is your duty imposed on you by the Constitution to perform that duty. So you must. So those who have made the petition against it, what are the grounds for which they have made the decision? And if she has a say, a defense to show that, in fact, she has not indulged in any of the things they are talking about, why not? You
say that cardinal principle of law that if you don't hear her side, how do you do the investigation? How do you investigate her without her side? That's your point, right?
That's it.
Is it the Council of State and the President who do the investigation, or it is the committee when it is set up that does the investigation?
If we want to go by the Tiger Eye one, Dairy one, what they are saying is that to determine whether there's a prima facie that a judge should be removed, you should give the judge a hearing. Give the judge a hearing. In other words, let her make an input into this prima facie thing that you intend to do. In other words, the president alone, some say is only a mere conveyor belt that he sends the thing. But if you read the section well, he is involved in taking that decision as to whether or not there must be a prima facie case.
Yeah, when the petition involves the CJ, but when the petition does not involve the CJ, he's actually a conveyor belt.
Exactly, he's also involved,
So my question to you was, is it the committee that investigates, or is the prima facie process that does investigation?
You see, those two steps are not very, very clear in my view. The three-member committee must have to investigate to find out whether there is a prima facie case. The prima facie case does not.
There's no a committee that does the prima facie. The president, in consultation with the Council of State.
Yes.
It is when a prima facie is established, then a 5-member committee is set up to do the investigation. Is that correct, sir?
That's why I'm saying that issue must have to be clarified well. And now we are doing a constitutional review. So I think we should clarify that aspect very, very well. Otherwise, like it was said in the Ajetum thing, the president can decide if he is to determine who, looking at the word, where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. So looking at the first part, where the petition is for the removal of the Chief Justice, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman. What does it mean? That once he receives it, then he can appoint the committee. That seems
Prima
to be...
facie. Prima facie.
Sorry.
Prima facie, in other words, is to determine whether someone has a case to answer. Is that correct?
That is what comes under 7. The committee appointed shall inquire into the petition, recommend to the president whether the...
Sir, this is my question. My question is prima facie. We want to assist our audiences. When we say prima facie, are we at this point trying to establish whether the accused has a case to answer? Is that what we are trying to do?
That is the point. Has he got any case to answer at all? That's prima facie.
So if that is correct, help us appreciate this. You've done many years of practice, including in criminal practice. Like we do in the committal proceedings. When is the accused invited to answer a case?
You mean when it is an indictment?
Correct.
When the case is on indictment. It's only after you have finished with the preliminary issues that you decide whether or not there's a prima facie case.
So the prima facie,
the circuit, the lower court will have to go through that process to determine whether there's a prima facie case or not.
Right. So that's a question I want to know from you. If you apply that principle, should the petition is against be called to give an opinion or response before the prima facie determination is done?
I think in both Ajetum and the Tiger Eye, what they are saying is that whenever you do some prima facie evidence, because you are going to investigate whether there is prima facie or not, remember that all the evidence of the statements and whatever it is in the indictable matter are put before the magistrate or the circuit court, especially the magistrate, to look at. So there will be evidence before them. Statements, whatever it is, to form that prima facie case to decide whether or not the case should go to trial. Isn't it?
Yes.
So if you have not heard anything, if you have nothing from the other side,
right,
what are you determining? How could you come to a conclusion that you think there is prima facie matter to go to trial? Okay.
So, like the example I gave, I want us to use that to see if we can help properly people understand. At the magistrate court, if you are doing the committal, the authorities are clear that once the magistrate finds that there is a scintilla of evidence, even without hearing the other side, they must commit. That's the authority established.
I'm saying that in that case, there's something before the magistrate, isn't it?
What is before the magistrate at this point?
The statements and whatever it is of everybody involved in determining, the prosecution witnesses, whatever. You have a whole a bill of indictment,
Right.
which is telling you where you are. And is the accused statement not part of the bill of indictment?
Correct.
Yes, you have everything before you. In this case, why do you want to deny the Chief Justice whose conduct you are going to determine the opportunity to tell you a reaction to some of the things you have to enable you decide whether or not the thing itself is frivolous? Because it's a very good position to adopt in the sense that otherwise everybody can file. And these were all discussed in the Ajetum, that anybody can just get up to file a petition against the Chief Justice. And in fact, the worst part is why it is said that where a petition has been referred to the committee under this article, the President may, in the case of Chief Justice, acting according to the advice of the council by warrant,
All right.
signed by suspend the Chief Justice.
Yeah, before we get before we get there, again, so the trial matter, the criminal process I'm trying to use as an example, I'll ask one or two more questions on that briefly so that we can proceed. You can charge an accused to court without a statement from them. Is that correct?
Yes.
Okay. And when we say prima facie in law, when lawyers say prima facie, and even when the law itself, like if you took the Copyright Act or intellectual property, they say registration is prima facie evidence of ownership, correct?
Yes.
Do you need to investigate before you can say it is prima facie evidence of, ownership?
The point I would like to make to you is that so long as these matters have gone before the Supreme Court, which have received interpretation, I do not think that we should go on the general, but rather zoom in on what we know. That Ajetum has made that point, that it is not fair to try and determine a prima facie case without giving the person a hearing.
Ajetum as a ratio, as an orbiter, Utaderi as an orbiter or as a ratio?
Whether it is orbiter or ratio, they make good points.
Ejeba here tells me that it was orbiter and not ratio.
Matter. For me, it does not matter.
No, we are educating our people too. What do we follow? When we say the Supreme Court has done something and it is binding, what is binding? Is it ratio or orbiter?
Well, as a lawyer, you will say that it should be the ratio decidendi of the matter.
Exactly. Orbiter is not binding.
As lawyers. But I'm saying that when the Supreme Court, the highest court of the land, has given a direction, then let us look at it this way because it's only fair. It is only fair to the person. I don't think we should ignore it completely.
Okay.
To say that was not what the case decided, so just forget about it.
Okay. I'll get to this with my guests, but I said I'll ask two questions about that. One more question about that, because last night I was reading Section 19 of the Evidence Act, Act 323, and it defined what prima facie evidence is, and it says that it's evidence of a fact that creates a rebuttable presumption. And then at Section 20, it says rebuttable presumption imposes a burden to produce evidence, So if prima facie is a rebuttable presumption, when you invite a response, have you not already rebutted the presumption at the beginning, even before the investigation?
And I'm saying that to avoid frivolous petitions being sent about Chief Justices and other Superior Court judges, these laws have been put in place to ensure that you do not permit an abuse of that process, like anybody saying that, as for you, I will have you removed by all means, and I'll file the petition to somebody. So the Supreme Court is saying, give that person, allow that person to be heard, give her something for you in even the determination of the prima facie case.
If the prima facie is to determine something which is inconclusive, something which is just a presumption, and then you invite a reaction, and the reaction deals with the matter and exhausts it, have you actually not turned the constitutional provision on its head that one step, there are 3 steps. One step is to make a prima facie determination, and another entity is supposed to do an investigation. Then, in the prima facie, those doing the prima facie, would they not have acted ultra vires their power, which is not to investigate, but only determine prima facie?
I don't think so, because with the adjectum and the rest, it is not only the letter of the Constitution you are looking at, but the spirit behind all those things should come in to help you to do your interpretation. So don't just go to the literal word, but propose it. Why are we saying that everything should be in camera? Why are we saying that? Is it not to protect the image of the judiciary? And secondly, why do we talk about prima facie? If the thing is frivolous, just dismiss it.
Okay.
And don't disturb the Chief Justice going ahead and even suspending.
All right. So I'll come to you guys later so that we'll look at the question whether prima facie, which means examine something on its face, does it mean investigate? And if you have a response, are you not actually doing an investigation? Prima facie, you may easily make, the inconclusive pronouncement. But if you go further to get, a reaction, have you not actually terminated what you are supposed to do if you found the prima facie? And have you not actually raised the burden for the petitioner in the process? Because the burden for the petitioner at the beginning is supposed to be a light one, as I'm reading. Now, so Honorable, quickly on the Attorney General going to the press and the criticism that what he's doing is prejudicial. He's trying people in the media even before they could be put in a court. Has he done anything wrong?
You see, for me, if you just want to inform the public about what you are doing with high-profile cases, that should be all. But you are also subject to the Constitution Article 19(1), 2B, 2C, which says that an accused person is presumed to be innocent until it is proved or he himself pleads guilty. So if the person is presumed to be innocent and you create the impression that the person is already, guilty, that will not be in sync with the Constitution. I don't think that will be in sync. But just to give us an overview of something you are doing, that look, there are few issues of corruption. We go into this matter, that we are investigating this, that. I think stopping that is okay. But to go into full details, coming to a conclusion that the people are already guilty, that is what raises up, because then it's going contrary to the constitutional provision that the persons are presumed innocent until you are proved again. The burden of proof is on you. You have not even charged them. You keep saying that, we are looking at you, charge them, we do this. Go ahead and do whatever it is, because the burden remains or rests on the prosecution throughout the trial. Nothing changes. So from day one, it is your business to do the investigations and put the person before court. If you come to the bar, the public bar, the court, public, to come and tell us that he has done this, he's told this, but what is it that you intend to achieve? Because all this can be in your facts of the case when you go to court and present it, charges before him and give the facts to the court, and then the media can take it up. I have nothing against broadly telling us what you are doing, but zooming in on the facts and getting to a conclusion of somebody having really done something wrong beats my imagination, whether it will be in sync with Article 19 2C.
All right. Thank you very much, Honorable Ayiko, to former Attorney General and Minister of Justice. Let me come to you guys quickly. I'll take your quick preliminary thoughts. We'll take a break and return to spend time over these. So, yes, Amanda, Prima Facie. But before that, I wanted us to begin from where we are now because of what happened yesterday. The suits, what happens to them?
Well, with me, Would you mind if we start from prima facie, just because we've been going on that?
Okay.
For me, I mean, I think prima facie means that the president, in consultation, so he's consulting for a reason. So he's consulting with the Council of State to determine whether a prima facie case exists in relation to misbehavior and misconduct. And then if it's determined, for instance, by what that council recommend to him, that it's frivolous and vexatious, then he'll say that there's no prima facie case, and then he won't refer the matter further. Prima facie basically means evidence. You see what I mean? For instance, when Akufo-Addo threw out Professor Asari's petition, I only just read it at 4 a.m. this morning, but it was actually a pretty decent document. Basically, does it meet the threshold of Article 146 in terms of evidence, not speculative, not rumor, and an appreciation of the administrative responsibilities of the Chief Justice? Because although the Chief Justice has a particular role, she has a very peculiar role, which gives her a lot of discretion. Do you see what I mean? And so, is the petition before the council? Does the petitioner have a clear understanding of the laws and rules governing the administration of justice and the peculiar roles and powers given to the CJ? And then I think the former Attorney General was quoting the case of Ajay Tum, that in that case it was said that it was distressing to note that nearly all the petitions were consistent of a second or third generation allegation against the CJ. So there wasn't anything coming from a victim per se of the CJ and things like that. So for me, that is what the council is actually going to be establishing. Because although on the one hand, public perception is, how come 95% of Akufo-Addo's cases, in terms of the Attorney General, went one way in terms of they won all their cases? What is before the council is a completely different matter in terms of they have to have a standard of misbehavior, incompetence, based on evidence, not speculative, not rumor, and actually come from a victim, perhaps, of the Chief Justice. So the standard is slightly different, in my opinion.
So have they been doing it wrongly, those that have allowed for the person who is to be investigated, who is accused, to bring a comment before a prima facie is made?
It's in camera, so it shouldn't have been done. But that's just a procedural infringement. It doesn't necessarily mean that it's a penalty, for unconstitutional disclosure, basically. So it should have been done differently, but there is a lot of public attention to this. And it's interesting to note that the rejection of Professor Asari's petition very well written. And I think it's that well written because the Chief Justice was allowed to give her comments. You see, so the way the current president has given her 10 days.
Do you know that for a fact?
Well, I think it was referred to her even before. It was referred to her even before it went to council.
In the prima facie determination as communicated by the presidency, do you find it there that the Chief Justice was giving? Because it speaks about consulting with the Council of State and then rendering that opinion. Yes,
but one of your journalists called me around that time, and I distinctly remember that as soon as there was word of the petition, the Chief Justice was given time to respond.
Okay.
Whereas in this case, the council has sort of seen the document and now she's been given 10 days to respond. So it's the same difference, but I do think that if she speaks to the procedure of what she does, because she knows what she does, and the other advantage of this council, it has the benefit of a former Chief Justice.
That's correct.
It has the absolute benefit of that. And I think she's going to be the deciding factor for this.
A former Chief Justice who is now within some quarters being accused of denying Charlotte Osei to see her petition and to make, an input before the prima facie determination was made.
Yes, but again, it is about the peculiarity of the role which only she can speak to on that committee. For instance, Professor Asari said things like the practice direction. She just kind of just issues all these practice directions and it's wrong. And yet, by law, practice directions are issued to bring consistency and certainty to procedures known to the courts that are yet to be set in writing in the court rules. So it basically means because she's seeing the reality of what's happening in the court, she issues a practice direction to be real.
Okay.
Another thing Asari brought up, for instance, he said basically that all cases can't go before the same judge. In terms of all cases for one person can't go before the same judge. But as you know, in practice, if like there's a lot of cases to do with one person and they all relate to the same matter, we're talking about consolidation of cases before the same judge. You see, so the peculiarity of the role is something the former Chief Justice can speak to help that counsel determine whether the threshold of evidence, not speculative, not rumor, has been met. Basically.
And your point, okay. Yes, Victor.
Yes, Samson, good morning. Let me just I want to make this observation that when we come here, we want to educate the public on some of the issues so that when we are talking, we are educating people not to take slants and others. So I believe in that. I think this whole issue about the removal of the Chief Justice has been settled by the Ajetum case. It's been settled. Even the procedure by which they have to go in Article 146, subclause 6, and going, it has been settled by Ajetum case. It says that when you read the Constitution, there was some lacuna that it did not talk about how the Chief Justice should be removed. But in the first place, first and foremost, she's a lawyer.
It did not talk about whether there should be a prima facie for the Chief Justice.
The Chief Justice.
So Ajetum said, of course, you should make a prima facie before
Exactly.
a committee is set up.
Yes, exactly.
Right.
And if I can read this, holding 3, what it actually said on Ajetum, it says the court would therefore declare that upon the proper purposive construction of the whole Article 146 in the context of 1992 Constitution, viewed in its entirety, the Chief Justice must be given the benefit of a prior determination of whether a prima facie case had been established against him before the President might lawfully establish a committee to consider a petition for his removal.
Must be giving the benefit of a prior prima facie determination.
Yes.
What does that mean?
Prima facie.
What does that mean?
Now, so the prima facie means that the first sight, right, once you look at it, the Chief Justice is given that benefit. So I'm sure whilst the response is being given, let me just finish, then I can read. Now, it says that whether substance in any allegation level against the Chief Justice in a position, the requirement for prima facie determination will not stop the process of holding the Chief Justice to account. The question of the prior prima facie determination and the subsequent appointment of the committee were to be made by the President in consultation with the Council of State. It will be prudent for the Council of State to evolve a convention by virtue of which the advice of a reputable independent lawyer will be sought as part of the consultative process with the President. So when it comes to Chief Justice and the petition is sent to the Council of State, they have the benefit that they can hire a lawyer, an independent lawyer, to look at the petition.
I think the question arising here is Article 146, Clause 6 does not mention prima facie determination for CJ when the petition is about the CJ.
Yes.
So this case says there must be prima facie before a committee is set up.
Committee, yes.
Does it say in this case that the CJ's response must be sought?
No, it doesn't say so. So that is where it went on and said that the process does not stop at the prima facie case. If it is determined that prima facie case has not been made, that ends it. But if it is made, the process continues. And when the process continues, that is when even you as a CJ, you have a benefit of a lawyer, you have a benefit of an expert of your choice. If it's borders on financial issue, you may have an accountant, you may have an auditor. So the issue where now another layer is being introduced, that at the prima facie case stage, you should be given that response opportunity that I have to respond. I don't think that that was the intendment of it. Because if you see the definition of a prima facie in Black's Law Dictionary, this is what it says: at first sight. So when you bring the petition, at the sight of it, at the sight on the first appearance, on the face of it, so far as can be judged from the first disclosure, presumably, a litigating party is said to have a prima facie case when the evidence in his favor is sufficiently strong for his opponent to be called to answer. So the Chief Justice will be called to answer if, on the face of it, they think that maybe what is stated is that she's taking bribe. I'm not saying this, Chief Justice, please. I'm not saying that's the case. I'm just giving an example. You've taken bribe. This is the evidence. If this is the evidence on the face of it, I see it, then I think that prima facie case has been made. Then the next stage is to give the opportunity to the person to come and respond to it.
When the committee has...
Yeah, when the committee. But what I think we want to...
What do you lose if you let them bring their response ahead of setting up the committee?
Yes. So you don't lose anything. That is why the Ajay Chum case is now saying that give the Chief Justice that benefit. Give her that benefit, or give him that benefit to be heard.
Read the words again. It doesn't say give her the benefit to be heard. It said give her the benefit of a prior prima facie determination before a committee is set up. Don't proceed straight away to set up the committee.
Exactly.
Because by the tenor of Article 146, Clause 6, it looks like straight away they should set up the committee until they're ready that there's a need for a prima facie.
Yes.
Right.
Yes. And if you look at the difference between what happened in the Professor Sari case, in that case, they said he brought no evidence. There was no exhibit. Nothing was attached. We don't know the kind of petition that has been sent. That there have been a dossier attached, exhibits that has been attached. Nobody knows the content of the petition. So if that is what has been sent and she's now being given that this is what we have against you. So she has asked for, and the president says, okay, this is what you have. Okay. And let's answer it. I think that is settled.
Very quick on the suits and the injunction application, and then Nana.
I think the suits is become, the doctrine of mootness. It means that when you come to court, what you want, before you come, it has been overtaken by events. So now that President has provided the petition, the suits and the rest has been...
Do you share in the President's disappointment?
The President's disappointment?
That it seems that the CJ was in a hurry because they were in the process and they were actually going to give her a copy.
Oh, everybody has a right to information. So if she thinks that this is what is in the public domain, I don't know what I'm being accused of, right? I want to know so that I'll be able to prepare for it. I think that it's her right that she would ask for. It's just that maybe it is coincidence that the president, in his mind, his intention was that I want to be fair, I want to be transparent, there should be accountability, I would definitely give it to you. Okay. And she also thinks that I need to look at it and have some experts that will look at it with me.
We'll go to Dr. John Osai-Kwapon shortly, but let's hear from Nanaje Bafwewa. And I monitored an interview you gave, and it was being suggested that the CJ has been denied something which is wrong. And you were insistent that is premature, that it is too early to be saying those things?
I don't know which interview, the content of it.
All right, so go ahead. Let's hear you.
Okay, so
of what has happened.
Thank you very much. My initial view in terms of the president's expression of disappointment with the CJ's communication, which was found in the public domain, I think that the initial error came from the president. Samson, we are talking about the impeachment of the Chief Justice. It's not a mean matter. It is different from the removal of the head of an independent constitutional body. That distinction ought to be made clear. We have three arms of government: the judiciary, the legislature, and the executive. If you want to remove the Speaker of Parliament, it's such a grievous matter. It's a very weighty matter. As opposed to if you want to remove, for instance, the chairman of a committee of Parliament. They are two different things. If you want to remove the if you want to remove the Chief Justice, that is the head of another arm of government, is so significant that that person cannot hear the news just like all of us do in the media. With the greatest of respect, even if the Constitution has said, which we all admit, that it should be an in-camera hearing, nothing stops you from informing the Chief Justice that I've received the petition and I'm taking the following steps, right? But for the Chief Justice to hear, just like we all did in the media, I think that the presidency erred. And in terms of disappointment, I think that the greater portion should be placed at the doorstep of the presidency. It shouldn't have been so. And that also doesn't make the Chief Justice's, the putting of the Chief Justice's correspondence in the media right. But I cannot say for sure.
Or copying those who should not have been copied as being alleged.
I cannot say for sure that it was the Chief Justice that put it in the public domain. And so I can't condemn her. But what is certain in this matter is that the president failed to communicate the reception of the petition to the Chief Justice. I think that was wrong. We should not be rushing to the media, right, in affairs of state of this nature. The impeachment of the Chief Justice is a very serious matter. In your interview I'm talking about, it was suggested to you that if it's been forwarded to the Council of State, then they are going to make the Prima Facie without the input from the Chief Justice. And you said, no, that was presumptuous. That was too early and premature to suggest. You see, I think, I've had a very careful reflection of this matter. Firstly, we all need to acknowledge the fact that as we sit here, the position of the law respecting Article 146 continues to evolve. Even after Ejechum, the Supreme Court acknowledged in the case of Derry versus Attorney General that, and let me read, that the question is this: if Article 1468 of the Constitution is violated in terms of public disclosure of the content of a petition, does it render the original process, being a petition to the president, null, void, and of no effect? This question has been posed because in the case of Ghana Bar Association versus Attorney General, right, and another, hereafter called the GBA case, as well as in the case of Ejechum versus Attorney General, hereafter called the Ejechum case, this question was not addressed and answered, even though this constitutional provision featured in both cases. And so the whole gamut of Article 146 seems to be evolving. And so that's the position initially I took. But upon a careful reflection and what we are dealing with, some said, I don't think we are dealing with a light matter at all. People I've heard, like I said, are comparing this to the removal of Madame Charlotte Osei and so on. They are distinct. They are distinct. It is not for nothing
They are talking only about the procedure.
The procedure. It is not for nothing that when it comes to the removal of the president, the Constitution calls it an impeachment of the president, and the procedure involves Parliament. It is not for nothing that when it comes to the impeachment of the Speaker, there's a gamut of procedure, and it is a very weighty procedure. And so, very respectfully, even in our interpretation of prima facie, we should begin to look at it in that light. And so, when you look at the Black's Law Dictionary of what constitutes prima facie, yes, it is looking at the document on its facie, its face. In fact, the definition of prima facie by itself, I mean, it speaks for itself, that on the face of it, on the face of what? On the face of what has been presented to you, when you look at it, it should tell you whether there is a case to be answered or not. And that is why the police determines a prima facie just by a complaint, not necessarily by, looking at the statement of the accused person, right? In some other instances, for instance, employee relationship, prima facie goes beyond just what the complaint is, because you are sent a query, your comments are invited, and then you give your comments. And then based on that, they determine whether to proceed against you or not to proceed against you. So we need to look at the context. And having taken a look at the context, I think that something, as I said, the gamut of law in that area continues to evolve. I think that on the basis of Articles 1, 4, 6, 10, and 8 alone, the comments of the Chief Justice is necessary. On the basis of Article 1, 4, 6, and 10 alone.
Aikoto was mentioning that.
Yes. You see, when you look at Article 1, 4, 6, 8, the whole proceedings is supposed to be in camera. And so it has come to our attention that there is a pending petition that is being looked at, right, inquired into in the case of the Chief Justice, right? But we don't know. It's supposed to be in camera. But at the same time, under Article 14610, the President has the power, on the advice of the Council of State, to suspend the Chief Justice. That in itself,
ending the investigation after a prima facie has been made.
After the prima facie has been made.
Yeah.
What does it mean? The Chief Justice has been suspended. We are here. The Chief Justice has been suspended. The Chief Justice's comments were not received. Then she has been suspended. No. It is a very serious matter.
From that point, do you think this process should continue to be in camera? It should be in closed doors?
No, I think it has to be in camera.
It has to?
Yes, it has to be in camera, because you may, as the Chief Justice or the Justice of the Superior Court, may as well be found not to have committed any wrong, right? But if you are not careful, you'd have soiled the person's reputation.
So a lot of exceptions. When it's about this Chief Justice, we shouldn't look at prima facie the way it is. We should find, a certain elevation for it, as you have said. When it's about an ordinary citizen, or when it's about independent of office holders of independent constitutional bodies, it's a lesser one. So you are not really bothered about that. When it's about ordinary persons, it's okay to proceed against them without hearing from them first, to determine prima facie.
You see, when it is about an ordinary person, he's not an office holder.
That's right.
When it is about an ordinary person, you are dealing with him in terms of the wrong that he has committed. When it is about an office holder, right, there are two levels. The fact that the person is removed from office doesn't preclude punitive sanctions, right, by way of criminal proceedings or civil proceedings. So there are distinct levels.
Unlike the criminal proceeding, where everybody has a right to go and sit in the court and watch and follow.
You see, even in civil litigation, we do say that the burden, the standard of proof, right, is what?
Preponderance of probabilities.
But when an allegation is made against a dead person, the degree is higher. The degree of burden is higher. And so you would appreciate that in law, based on the circumstance, different scenarios play out.
Right.
And that is why in this instance, we have to be very careful. Because it cannot be that an impeachment proceedings against the Chief Justice that potentially may lead to his or her suspension before the hearing actually even commences, and then the final sanctions are imposed, right? Her comments will not be received prior to
So the
suspension.
Chief Justice herself,
Yes.
when it is about other people and the petition goes to the president and they take it to her, she insists that you must bring your comments before she will do the prima facie.
Yes.
There's actually been an occasion
The
Where-
OSP case.
where a petition was forwarded to her
Yes.
and she said, bring your comment before I make my prima facie. And the other person said, my understanding of prima facie is that it's your job. I don't need to bring my comments. And she said, bring your comments. If you don't bring your comments, then perhaps I'll just go ahead and say, prima facie is, and then you are in trouble, you know?
Yeah.
So do you stand the same place where your colleagues stand? That the suits, the two suits at least, by Ebenezer and Vincent Assefuah, and the injunction application, all of them have become
No. They are not.
otiose, moots?
The injunction may, but not the substantive matter. You see, this discussion presupposes a fluid area. And so it's an evolving matter. It has happened for the purposes of future, for the avoidance of similar or possible mistakes in the future, right? In terms of how we deal with matters of this nature, right? The Supreme Court will still proceed.
But I thought I have heard over and again that the Supreme Court has already pronounced on this. So there's no
The
need.
Supreme Court has not pronounced on the procedure in terms of what amounts to prima facie.
Whether you should bring a response or not.
Exactly.
Okay.
It's not been determined.
You disagree with those who say it's been determined?
No, it hasn't.
Okay.
Because you see, when you look at the obiter, right, that is the comments made by for the purposes of your readers, by the side or by the way, in the case of Derry versus the Attorney General, right, suggests to you that there is even it's not a settled area, okay? And how they even evaluated the prima facie confirms my position that indeed, because it's a quasi-judicial function, a decision, a comment must be invited. That procedure has not been resolved. It's something. You see,
But the suit is not in a vacuum. So if you say the suit remains, the suit is mounted on the basis of the CG not having been given a copy for her response.
Samson, you and I know that in practice, the Supreme Court had gone on to say in some instances that even though this has happened, we think that for the purposes of the future, we'll make a determination so that we settle it. I think that this is one of the areas, especially because, as I said, after AJHUM, everybody thought that the matter was settled.
Yeah, but Ikotu just said that the Supreme Court is not an advisory chamber.
Then subsequently, it has come to acknowledge that after AJHUM, some matters still linger. Now, today, many years after Derry, right, we are seeing what is happening.
But even in AJHUM 2005, the Supreme Court said that there should be rules. We should make rules for this process.
Convention.
And it has not been made.
Does that not
Consequential
confirm our
enactment.
position?
Okay, let's
That
go
confirms
to
my
Dr. Osai Kwapong. Thank you very much for joining us, sir. Hello, Doc. Please unmute your mic.
Can you hear me?
Great, I can hear you. So tell us, what does the Afrobarometer say on this matter? You are the Afrobarometer man.
Good morning to you. Good morning to your viewers and the other panelists as well. Unfortunately, on this question, there is no Afrobarometer answer.
No. There should be.
But I've been listening to all the insightful comments from the panelists, the legal education and everything. For me, as I've been reflecting on this case, and as I wrote about it yesterday for CDD Ghana, it is an extremely weighty matter and issue, to contemplate the removal of the Chief Justice of Ghana's Supreme Court, which means that I can see why the Constitution tries its best to create a process where you have to cross a number of hurdles before that ultimate decision can be made as to whether a Chief Justice remains in office or not. In particular, you don't want the potential removal process to be a tool for resolving deep disagreements with the judiciary or deep disagreements with the Chief Justice. So you want to make sure that you insulate the process from some of these things. On the question of whether the Chief Justice should have been, giving the petition so she can give an input before the president consults with the Council of State. In my opinion, whilst it is not prescribed in the process or in the law, I think as a matter of good governance, it would have been helpful, right, in the president going to the Council of States to say, okay, look, I have this petition against the Chief Justice that I want to consult with you about. For me, it hurts nothing if you go to the Chief Justice and also say, look, here's a petition. I want to, go to the Council of State for their advice. It won't hurt if I at least have some initial comments from you on what these petitioners are raising or alleging. And then you go to the Council of State to say, look, I received this petition. Here are some initial comments too from the Chief Justice. Weigh it all and advise me, right? In that case, you are giving the Council of State the benefit of even more and additional information. It's not that they won't be able to advise you on just the basis of the petition, but I would have liked a process where you get some initial comments from the person against whom a petition is being made, so that the Council of State has this, wealth of information upon which then they can advise the president, during that consultative process to say, okay, there is some prima facie case. Then, at the next step, the Chief Justice would have, the benefit of fully responding to whatever is being determined in the initial stages.
Is that to suggest that the approach is wrong to begin with the Council of State, even if you intended to get to the CJ, as we are being told? The Constitution provision says, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State. You are saying that the right thing is to get to the CJ first, rather than consult with the Council of State, and to have the Council of State now say, upon the consultation with us, let's call the CJ to bring her views. Is that what you're saying?
No, I'm saying that in the consultation process as prescribed by the Constitution, I think it would be helpful to also have some initial comments from the Chief Justice.
Yeah, so my question is, which should start first? The Constitution, which should start? The Constitution says, if it's about the CJ and you receive the petition, you shall in consultation with the Council of State. So should he begin the consultation with the Council of State, who should he inform first, the Council of State or the Chief Justice, to begin the process? That's the question.
Right. To begin the process, he can go to the Council of State and say, I have this petition against the Chief Justice. But as part of the consultative process, permit me to do one more thing. Let me get some initial comments from the Chief Justice as I'm consulting with you to get your advice on how to proceed on this matter.
Okay. What do you say to those who say that will mean the president is actually from the onset dictating to the Council of State whom he's supposed to consult with for what should happen?
But he's not telling the Council of State or dictating to the Council of State what they should do or how they should advise him, right? He's essentially, at least for me, what I see such a step doing is to say, I am looking for your best possible advice on this matter. I think it would be helpful as I consult with you if I can also have this additional information at the beginning of the process, right? Yes, I know that if a prima facie case is established, the Chief Justice would have a chance to respond, etc., etc. However, at this point, at least I would want some initial comments to add to what the petitioners have brought before you, so you can give me your best possible advice as I consult.
We just heard former Attorney General Ayikwe Otu, who says former Chief Justice Sofia Akufu, who is in the Council of State, on the Council of State, potentially will have a key role to play in this process. When Samoku Jeto was there, he tells us how he was heading this kind of processes. Imagine that, assuming without admitting that when Charlotte Osei was not given the opportunity of seeing her own to give a response before a prima facie determination, who was the CJ then? Sofia Akufu. So imagine that her view is that you don't have to give the other party the opportunity to give a response. And she's in the Council of State. And you've already gone to take the response and you are coming to give it to them. What is she going to say then?
I mean, if she still holds on to the principle she applied in the Madam Charlotte Osei case, I can see her saying, well, Mr. President, you didn't have to do that. But again, for me, it's not about the president violating the process, right? It's about the president saying, given the nature of this matter, given the institution that we are talking about, I think that it would be helpful to bring you some initial comments from the Chief Justice, because the matter we are dealing with is an extremely weighty matter that involves the potential removal of the Chief Justice.
Okay, I'm going to take a quick break. When I return, Doc will be answering the question, should these processes continue to be in secret or to be in the private, as is being proposed by others, that no, this is very important. The public must be aware from beginning to the end. Also, because they feel that this may also cure a certain political mischief in the abuse of the process. But before we go on the break, Kwame Akufu is a lawyer, the kind that Ejechum recommends to the Council of State. Ejechum recommended there should be a reputable lawyer to assist the President and the Council of State to make a determination of the prima facie. Kwame Akufu says the Chief Justice has a constitutional right to be heard before a determination can be made as to whether or not a prima facie has been made. Be that as it may, and with all due respect, she spoke too early. Prof, you'll be answering that. She spoke too early. Tactically, she could have remained mute and watched the process deviate from the constitutional path. Subsequently, upon a finding that a prima facie case had been made out without her having been heard, the CJ could have raised a complaint of constitutional infraction. This will have scuttled the entirety of the impeachment proceedings, because we do not know the motivations of those who determine our fate. The resort to tactical maneuvers founded in law is a useful aid. By virtue of the learning in the Tufor case, the CJ will not have been stopped from challenging the constitutional flaws. The CJ spoke too early. Kwame Boafo Akufu Esquire of Ekropong Ekwapeng. That's strategic. We take a break, we'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Now, just too many lawyer colleagues sending messages now, just clapping for Kwame Akufu and his strategy. And it says, absolutely, you know, what I am discussing now, what Kwame Akufu shared with you, I hope he has lawyers who would think in this way. Yes, a couple of people suggesting same. And then Kweku says that it seems all your guests share my view. We need to do a review of Article 146 to clearly reflect these views shared by your guests. Okay, so questions coming up and you will deal with them. This one says, I have a number of questions. How did the MP who took the suit know that the Chief Justice had not been written to? Did he consult the Chief Justice? Why was it an MPP MP who filed to demand for it? Why the U-turn to demand for copies when the process was in motion and not finished? If you file a response at Prima Facie and the Council of State comes to a conclusion, you have a case to answer. Which other evidence or response will you provide? Shouldn't you be dismayed straight away? Okay, and then, well, in the Tiger Eye case, Nana J is, and let's be frank with you, all of our viewers and the people that watch and listen to us, in Derry, they didn't make a decision that is binding on anybody. It was an obiter, which means it's just a comment. It's not part of the judgment. So, yes, side comment. So the law has not been changed to say that there must necessarily be a response before a prima facie is determined. In a JCHUM, they said there must be a prima facie before the committee is set up, because Article 146, Clause 6 does not say there must be a prima facie. So they wrote into that law. Thank you. Yes, sorry, I almost thought I'd finished reading the messages. Godfred Pencil says there are so many wrong actions carried out by, it's difficult to say, by her leadership, the Chief Justice. She shouldn't have moved. Okay, sort of joining Kwame Akufo. Maunyo says the CJ has proven. Okay, I'm unable to share this, your comment of yours, because I know better that this comment should not. Papa Kwejo says Article 1461 outlines mandatory exceptions. She can be removed if the said petition exhibits beyond reasonable doubt her inability to perform the functions after a fair hearing in camera. Then Council of State can advise Mahama accordingly. The suit and her letter are irrelevant to the process. Then police tweeting at 91 says she weaponized. Okay, those comments, I beg you. Afri Fair says most honorable thing for CJ at this point is to resign and not to fight back. Clearly, she hasn't lived up to the task. Junior Jakpa, really, says it's purely professional. We don't want unanimous FC anymore. Then Owusu Ansa says 100% she should be removed. But you haven't even seen the petition, so what are you talking about? The rest of what you have written, I am unable to share. Forgive me today, some of the things you people are sharing today, I'm unable to share them. So, gentlemen, once again, are these questions germane? Yes, Amanda, are these questions germane? How did the people get to know that she has not been served and went to court so quickly and all of that? Kwame Akufo's strategy would have been the best way. Wait for the sin to be committed, then you strike.
It is a very good point strategically, but I think the bottom line about Prima Facie case is factual evidence, that is factually accurate evidence and the law. For instance, going back to Professor Asari's petition, because, that's the one I read before.
The one dismissed.
That was dismissed. It was dismissed partly because, for instance, he used the words reported incidences instead of a disclosed, yes, an aggrieved victim of the Chief Justice, etc. Furthermore, he said something like, there have been reported incidences.
So can we deal with what I'm talking about so that we, let's leave Professor Azan's petition, which was dismissed, aside. The question is, so we're answering the questions that our viewers are asking. Yes, I'll come to you. That the person who sued, how did the person get to know that the CJ has not been served? Did the person ask the CJ and did the CJ tell the person, what's wrong about that, really? Why was it an NPP MP? You know, are these...
I think, obviously, if it is an NPP MP, perhaps, you know, at that level, he did have a discussion with her. He wasn't, you know, just blindly going to file a suit. But again, does it really matter? Because what he's trying to get out of this is, A, natural justice to flow, and that she has a platform. And maybe he consulted her, maybe he didn't.
But the natural justice question is being said that it's not as if you will not be heard.
Yes.
If you are not heard in Prima Facie, once Prima Facie is determined, you will now, a committee is set up and you will now be giving the petitions for you to answer.
But the point is, as he just said, that this is not a light decision for a Chief Justice to be impeached. So what has been introduced in the Constitution is that at every level, should this be wrong, including that first hurdle, it is thrown out as frivolous and vexatious. So at that first level, do you see what I mean? It is important to have her input. Because for me, if you don't have her input, then she can, for instance, speak to the peculiarities of her position.
Which she will be speaking to at the investigation.
Yes, I know, but if she answers that at that level with a council, including a former Chief Justice, a former Attorney General, and people who can respond to that and have been assembled for this purpose, then
Will that still be Prima Facie? Prima Facie is inconclusive evidence. It's inconclusive situation. It's a rebuttable presumption. Would the presumption not have been rebutted already?
Yes, it's a rebuttable presumption.
Right.
But it's also based on evidence. You see what I mean? And if you're talking about evidence, she must be able to adduce her evidence
Thank you.
as well.
Yes. The questions, let's answer the questions by our audience.
Yes, the audience.
Is there anything wrong with that?
There is. You see, when you are put in a position, depending on your status in society, things you say, when they connect the dots, it leads to a certain point. Now, Asefwa being an opponent,
they also mentioned the lawyer who is a former
the lawyer who is a former Attorney General. And my very good brother here, in one of the interviews, said, it is frightening. I'm coming. Oh, wait.
Imagine.
Wait. With Paul Adom Autry.
I don't remember the thing.
With Paul Adom Autry.
With
Paul Adom Autry. He said, the removal.
I'm very happy this has come
up. So if you connect all this dot, how did Asefwa get to know that the Chief Justice had not been given the petition? You see, if you look, the presidency has done the right thing because 146 has laid down a procedure. When the law lays down a procedure, that is what has to be followed. The Prima Facie case is just on the side. Look at it. Is there enough evidence?
What's wrong?
Wait, I'm coming.
What's wrong that the petition is forwarded to the Council of State?
Yes.
On the 24th.
Yes.
And then 2 days later, is it? No, the Asefwa's suit is 27th, right? The morning of 27th, 9:30 a.m. That's almost 3 days. Is it not possible that somebody at the Council of State may also have spoken to Asefwa?
Yes.
What's wrong with a former Attorney General who now has his private law firm representing the Chief Justice, or representing someone who has taken a suit about something that is happening to the Chief Justice?
No. The question we are answering is how did they get to know? Was there communication between the Chief Justice and them? The Chief Justice is entitled to anybody to represent her, entitled to say, this is the issue.
So what's the wrong?
There's nothing wrong with it. But
so what's the problem?
What I are saying is that now the issue is that, you see, they are saying that what the presidency did without giving her, it's wrong. And I'm saying that no, that's not a position. There is a procedure.
Okay.
They have gone through the procedure. Now, if you invite comments from her, at the prima facie stage. Now, what work is the committee going to do? The committee going to investigate. So, are we saying that at the prima facie stage, they will investigate? Then what is the work of the committee that will have to be done?
I ask
issue.
Aiko to
Now
all of
we
that.
are
I even ask Aiko to
and say that
the fact that you are inviting the other
natural
party,
justice,
is it not an admission that prima facie you feel there is a case?
Yes.
That's why you are inviting the person to bring an answer. But let's move on. We have moved on.
Yes.
Nana, you should have a different view about, because whilst he seems to say there's nothing wrong with Asefua getting to know or Dami being the lawyer, he seems to suggest there's something untoward.
So, my brother, I thank you very much for bringing up this issue. Actually, I've seen a blog, somebody blogging a video and a comment they'd made about me saying, about having said it's frightening in my conversation with Admotri. It was in respect of how easy it is to suspend the Chief Justice.
That's right.
Yesterday, somebody called me and said, when Paul said that who would replace the chief, who will act in the stead of the Chief Justice in the event of the suspension.
He said the next most senior.
The next most senior. And so when Paul said, who is that? And I said, Bafuboni. And Paul said, Justice Bafuboni. And Paul said, it's frightening. And I said, yes, it's frightening. And it's been interpreted to mean that the appointment of Justice Bafuboni will be frightening. No. How easy it is to suspend the Chief Justice. Because you see...
Okay. So now you have explained.
Yes. Because, bro, let me add this quickly. Some of the instances where you hear in other countries that a Chief Justice has been fired by the president, you know, at this point, it is dawning on me that a Chief Justice in Ghana can be suspended. That is why I said it is frightening. Yeah. Right? Now, let me move on. My brother, where the information came to my good friend Asefua, respectfully, I don't think that it should be that relevant in the discussion. If you look at Asefua, he's been very proactive now. I mean, going to do videos on abandoned, uncompleted projects and so on and so forth. He's very proactive. Yeah, bringing out a suit against
dismissed employees.
Yes. Okay. Asefua has been very proactive these days, right? I mean, he's taken his duties as MP to a different level, and he must be commended for that.
He started writing legal articles before he left the law school.
He's very active. Now, that said, we all know how information do come out in this country. I mean, my good friend, Honorable Okudzeto Ablakwa, the Minister for Foreign Affairs, was getting information about the president's travels. How was he getting it? Was it being leaked by NDC elements there? So please, I don't think that is consequential. It can even, like Samson's alluded to, a third party, right? And so I don't think that is even material. And the lawyer he goes for, I will go for Dami any day, right? I will go for Ayiko any day. I'll go for Kwame Akufu. I'll go for Tad. I'll go for some of the big name lawyers. In fact,
I don't mind about what they say is the optics that there are accusations.
The CJ,
there are insinuations.
It would have been problematic if the CJ had gone for Dami. Those insinuations would have become very fertile if it was done.
I get that point, yeah.
You understand? But this time...
It's not the CJ.
It's not the CJ that went for Dami. It's Asefua that went for Dami. And he has a right to counsel of his choice.
Yes, right.
All right.
Good. Now, on the issue of whether the CJ should have taken her time...
and wait for the sin to be committed.
I mean, if you're a litigator and you watch these things play out, you'll be laughing.
Yeah.
Because, you know, our job... Mostly I tell my juniors in chambers that it is not so much about the law, right, but strategy.
Strategy.
Yesterday I was laughing with a very senior lawyer I respect a lot, Justice Kusimenka Premo. Justice Kusimenka Premo will find a cause of action even in the one word you use. Have you seen his suit for in respect of the OSP, the letters he was writing? So it's about strategy. You open yourself up to be struck. That is what litigation is about. But in this instance, I think that dependent on who you consult, you have to play out different scenarios. You are looking at the power of the CJ, taking into account the jurisprudence in that sector. You and I know that when you look at the jurisprudence, one of the most difficult things to do in this country, right, is to come up against a judge. Look, take Attorney General versus Salah. When there was clear evidence that Salah was a good friend of Justice Apalu, there was clear evidence. The late Victor Usu had written, right, to confirm that I play golf with Justice Apalu. I know for a fact that Salah is his friend. The court said, yes, undisputably, they are friends. But the question is the degree of friendship. What is the instrument for measuring the degree of friendship?
In a Ghanaian society.
In a Ghanaian society.
Where everybody knows everybody.
Exactly. Now, look at the gamut of authorities, even on Article 146. It's just like a snake that continues to evolve. And so for me, if I was in the position of the Chief Justice, I would assess the scenarios. That look, my greatest tool is when I am in office and have the power to constitute, right, the panel that will sit on this matter. If I wait to be removed from office, that power is gone. And I don't know the extent of my loyalists, right? The number of loyalists I have there who protect me. Okay? So what do I do? Right? You have to play all these...
You strike early, the case comes, you have the power to determine who sits on the case.
Exactly. You see, you have to weigh all the scenarios. If you don't weigh all the scenarios, that's what I'm saying.
Doesn't that sound a bit problematic morally and the sense of justice?
Well, the sense of justice, morality, and all that, they are very important. But the evolution of the Constitution and the preservation of one's office may also be taken into account when making such decisions.
You see the issues people are raising, that there was e-levy injunction. How long did it take? Was it ever heard? In this case, there was an injunction filed on the 27th, and then we are told that the next...
this matter,
it will be...
Please.
Do you get that?
Wait.
No, I'm talking about bringing to your attention the issues of the optics, which can also inform, the poisoned mind.
Samson, the CJ is herself a subject of litigation. You are counsel to the CJ, right? You need to advise her, okay? If you have to advise her on the theory of the law, it is different. But the practice of the law, which I call the wisdom of the law, is distinct. And so at that point, as a litigator, as a lawyer, as a trial lawyer, you are called upon to make choices. What choice are you going to make that will give her effective results?
No, so are you saying
you have to play out those
interest and what your public duty?
When your client comes to you,
it's a little bit slippery. I see it because
I am saying that I am playing out scenarios.
So you see, you should buy this. You see that the Prima Facie thing, he elevated it to a certain extent on the basis that the office of the CJ is third in the arm of government. And so not to be construed the same as ordinary people and everything else. Now, natural justice rules.
Yes.
For as long as he's Chief Justice and the case has come, she must empanel. And there will not be questioning about conflict of interest or natural justice, correct?
At all.
So there can be exceptions.
Yes, but what I'm saying is that, you see, the Prima Facie, the determination, is even a tall order. It's a tall order for that to be determined, right? The reason why I'm saying that, look, we have seen it in this Fourth Republic. Justice Akwa, Georgina Wood, Sophia Akufo, Enim Yeboah, Gertrude Tokonu, all of them, there were petitions. Where did they get? He did not meet the threshold of the Prima Facie case.
Some of them were not actually spoken about.
Some of them were not.
There were petitions that were just buried because the presidency didn't feel you should move them.
Yes. So now that this case is coming, I think she has the opportunity. And for me, as a person, I'm happy that we have the constitutional review Because this is something that we are looking at. So, and the constitutional review body can look at it.
Dr. Osankwapo,
that's what a member of the
the constitutional review committee, they can take 146.
On TV, you are whispering.
146 and look at it and say that look, this is becoming problematic. And they can look at it.
Let's bring on Doc.
Ayaku Kosa was sacked, and that is why in the 1996 Constitution they started to put the procedure, and that's how we've had the Third Republic and the Fourth Republic.
Okay.
But at that time, the president.
Let's go to.
So they said
Doc is part of the panel. Please hold on. Let's go to Doc. Yes, Doc. Should this process be made public rather than secret? What does it portend if it's made public? Yeah.
If it's made public, it prevents, whenever there is an information vacuum, people fill that vacuum with their own innuendos, speculations, thoughts, you name it all. So the benefit of having such a process made public is you and I get to watch, see, and hear the same thing at the same time without all of the speculations that can come with it, right? Because when it is shrouded in mystery and, not to make prejudice statements or comments about what the eventual outcome is. But if you think about the potential removal of a Chief Justice, and yes, that processes are going on, and then eventually, let's say the decision is made that the Chief Justice has to be removed. You can only imagine, especially in a polarized political environment, what the narratives would be like that emerges from this. So that would be, for me, one of the good benefits, the transparency part of such a thing. But the caution that I would throw to is that, and now let me give you something from Afrobarometer. So if you look at the first significant decline in trust in the Electoral Commission, it happened in 2014. And why did that happen in 2014? In my view, it was coming on the back of the 2012 election petition, that 7-8 months of hearing, where publicly we all got to see some of the challenges, some of the flaws in our electoral system, which I believe shattered people's confidence, and trust in the system. And I think over the years, the EC is still yet to fully recover from that public exposure of what the 2012 petition hearing did. So again, my caution is, depending on what the matters that would emerge in such a public hearing is, you have to pay attention to what it does, not just to the person in question, which is the Chief Justice, but what it does to the institution. Because you can, in pursuing transparency, you also want to make sure that you do not weaken the institution in the eyes of the general public.
Right. Prof, like I suggested in the Dampari situation where, I got mauled by a horde of police officers, there is history. Not only in the Akufo-Addo mills, people file petitions, but the petitions are buried. The appointer, as in the president, will see the petition and say, Charlie, I don't want you to disturb my person. I won't forward it. I won't do anything about it. I think that is what led to the wisdom in the OSP Act. The OSP, the SP is also subjected to this kind of process if you want to remove them. So you see in the SP Act, they provided that if the president receives the petition, within 7 days, he must forward it to the Chief Justice. If the Chief Justice receives it, within 30 days, she must make the Prima Facie determination. Then within 14 days from that, she should set up the committee. The committee has 90 days to do the hearing and forward the process. This constitutional process for all of these other people, there are no rules, nothing. So in the same way that the president can see a petition and bury it and hide it, and as I mentioned for Dampari situation, what sins did they level against Dampare that the president could not say, call the Dampare and sit down with him and say, look, can we agree on ABC? The people are not happy with you about this and that. So can you change your ways about that? And then the person stays. Can this be applied? Can the presidents do this? And I might be suggesting that there should be a breaking of the law. But can this happen?
Well, I mean, the danger with, I can see in the Dampare case, right, you're still talking of a part of government that is part of the executive, or at least the executive branch. I think it's a little tricky when you're talking about the judiciary and the independence of the judiciary to try and say, okay, Mr. Chief Justice, Madam Chief Justice, look, these are some of the things that people are saying. You see how best. It becomes very tricky, because then are you, if I was the one who appointed you, right? Am I trying to protect you by not letting the process move? Because somebody can bring an egregious case against the Chief Justice, and I can exercise that discretion and say, look, people are saying these things. If that's what is going on, stop. Right? That becomes the danger. When do you make that distinction between the proper cases where you can?
We have seen that the process is prone to abuse. Must removal, the ultimate sanction, be the way to enforce some discipline, for wrongs?
No, and in fact, that's why I also said in the beginning that for me, and if you look at the response of the president to the Professor Asare petition, right? You see that the president goes through a lot of pains to try and convey this message that ultimate sanction of removal has to occur, in my opinion, when the sins against the Chief Justice is very egregious. And so for me, the lessons here is that we just have to make sure that we are not trying to use, and I'm not saying that's what's going on here, but we have to be very careful not to paint this picture of this removal process becomes a political tool for resolving a deep disagreement with people we may have, differed on, or whether certain processes.
Hold on for me. For me. I'm going to play President Mahama speaking at one of the meetings with the NDC lawyers group, and without seeking to show any disrespect to any of the petitioners whom we don't know, they're suggesting that these petitioners are rented and to help to do, they are doing a hatchet job. Let's listen to President Mahama.
They can get any justice from the system. There's therefore the urgent need for the Ghanaian judiciary to work to win the trust and confidence of the citizenry and erase the widely held perception of hostility and political bias in legal proceedings at the highest courts of the land. Unfortunately, we have no hope that the current leadership of our judiciary can lead such a process of change. We can only hope that a new Chief Justice will lead a process to repair the broken image that our judiciary has acquired over the last few years.
Prof, did you mark those words?
I did.
And then tell me very briefly.
It's unfortunate that the ladies of the court would, on oath, tell a bare-faced lie to the court. Now, this is the narration of the. I received a call, and
Sorry, who's on the line?
Who's on the line?
Okay. All right, that was an error. Please forgive us. So, Prof, the president in opposition had no trust in the judiciary and the leadership, and that for something good to happen, there will be the need for a new leadership. These petitions, what a coincidence. Some will say, but there was one in Akufo-Addo's time. What do you say?
And you see, that is where some of these previous comments come back to haunt even the legitimacy of some of these processes, right? If you recall in the EC case with Madam Charlotte Osei, the process itself would not have been subjected to a lot of some of the conversations if in the lead up to the 2016 election, there weren't comments that suggested that should a particular side emerge victorious in the election, it would result, we would have to do something about this, right? And so for me, again, this is one of the cautionary tales to our politicians, and sometimes some of the statements they make, because they can come back to haunt them, because now, even if this is a legitimate process, people just go back and recall some of past statements and think, oh, there's no coincidence, about this, But
Okay.
again, for me, we just ought to, be very cautious in how we proceed. The last thing I would say is, yes, I agree. If you look at the Ibrahim Index of African Governance, if you look at the Afrobarometer survey, there is really some major issues that our judiciary faces. But here's where I also give some credit to the Chief Justice. There's an initiative that has not gained a lot of public traction, the Leading Justice Initiative. This is a strategic framework that she announced in 2023 as a way of correcting some of the challenges that the judiciary is facing. It holds a lot of promise. I'm just hoping that regardless of the outcome of this process, right, that the stakeholders would throw their weight behind it, because, yes, there's that recognition that our judiciary is not enjoying the best of time.
Prof, you see why I say there should be a way you can negotiate out of these things. All right. Yes. So what do you say to this tag that, and once again, I say, without intending to show any disrespect or disregard to the petitioners, because we do not know them.
We don't know them. Yeah.
But the thing is out there that these are rented to just help an agenda. Very brief.
Yeah, very brief. I think that issue came up in the Ajay Chum case. The person who comes, or the petitioner, and the court dismissed it that anybody, just like under Article 2.1, who feels that something has gone wrong should come. So anybody can come. So whether it's rented or not rented, I think that case is settled. Now, looking at let's put it in context what Mahama said. This was during the time of CJ Enim Yeboah, when that conference was held. It was in Akosombo, when he was a CJ. So he was saying that the current leadership under Enim Yeboah, the perception that there is no trust, cannot be trusted, and they cannot correct the system.
You were at the conference.
Yes, I was there.
And you were a member of the
yes,
the Splinter NDC Association.
Yes,
no, I wanted that to be on record. Don't worry.
Unrepentant member of it.
No. I wanted
a very dedicated, committed member of the NDC lawyers group.
Good.
Yes,
I just wanted to be sure of that.
No, I'm a leading member of that group. I think I'm not ashamed to say that.
So thanks for the context.
Yes, so putting it in context, so he was saying that the new leadership that would come, he believes that they can do something about it. And I think that was when we had the FC unanimous, because everything was being done. But I think that there had been
the
some...
unanimous FC continued in...
Yes,
George, I said George. Saki's time as well.
Yes.
Okay, and people are saying, if you have a desire to do this, don't forget that the MPP is there as an opposition. There will be decisions. They will also be doing the same thing. Will you be happy that the Mahama regime or the NDC regime appoints, a chief justice, and NDC is saying unanimous FC, when MPP is saying unanimous FC, once there's a judgment they disagree with, they say this is so. Where will we go?
Yes. You see, I always say that, listen, we can have all this FC. It's all about perception. But at the end of the day, it is the law, the competence that leads.
Okay.
None of those people, right, they may have their biases, their alliances as Supreme Court judges. But what took them there is competence. They may be, impartial, but what they do, there is fidelity to the law.
Oh, you agreed to that?
Oh, yes, yes. I'm a lawyer.
You agreed to that?
I'm a lawyer.
That when you lost your election petition, it was fidelity to the law, you don't have to blame them.
No, you can criticize and say that...
The president was there criticizing. You didn't tell him that.
No. You can criticize and say that this is what the law says. But I think with this one, that's why we can criticize judgments. We criticize judgments when judgments come and we think that you haven't done the right.
You just made a statement that what they have been doing is fidelity to the law.
I'm saying that is what should be the guide. That should be the hallmark.
But that's not what is being done. Is that what you're saying now?
It's not always, you and I know as lawyers that it's not always judges do what they... Even there are occasions. Let me tell you one occasion. I did a case in the High Court. We lost. When we went, the judge was up. Later, I met the judge. The judge said, you know what? I was just appointed at the time. I had not even read the company's code.
This is serious.
She had not... No, she confided in me. That is not to say that they don't make mistakes.
That's grounds for removal. Yes, Amanda.
No,
Amanda,
because
this thing about
that,
rented people and so on. What do you say? How does it feed into the whole thing?
I think it would be pretty bad because, for instance, should these petitions carry and, you know, basically she's removed, it would set a very bad precedent in terms of it means that every government that comes in can try and justify it, particularly if it is a rented petitioner, etc. So we have to ensure that it's not a slippery slope in terms of that the standard is very high as to what...
You don't join those who say she should not fight it, she should just check out.
Oh, no, I mean, because she hasn't done anything so grievously dishonorable to the profession that we have heard of. So I don't think she should just do an honorable resignation, etc. Because this position is not per party. Do you see what I mean? And so if she held her ground and she says what she wants to say, we can see if the petitions are frivolous and vexatious.
Okay.
But it is a bad precedent if, for instance, this council does not understand that a prima facie case literally means evidence. It means, actual facts, evidence, and talking about direct victims that have suffered at the hands of the Chief Justice. And if they don't meet that standard and it keeps going, and she's out, then thereafter she can go before the same Supreme Court as a private citizen and go into the law and go into the procedure and go into the factual basis of why they reach that decision. So it is a slippery slope if they don't have a high bar. But, there's very competent people on that council.
You mean as in, if in the end this led to her removal, then as a private citizen, she can take up a suit
yes, she can.
In the court to challenge the decision?
Every single person in this country can do that.
It's not going to be easy, though, you know that.
It would be easy if she sides law.
I like Kweku Bako when he took up the suit to challenge the removal of Charlotte Osei. I can tell you it's not easy.
Yes, but based on evidence, it has to be based on evidence.
Would you also suggest, like they're saying, that she should just, after all, what is it? You just tell herself, well, I'm a successful lawyer, I've been a judge for many years. If you want to use this to, as it were, debt me, then I resign and leave.
Matt Lingin, for me, sometimes you always have a right, but it's not always you insist on your right. It is good. A good name is better than everything that you do. Like you said, if this is the system, and I insist, I've always believed that you can't fight with a government.
Make the point. Yeah,
you can't fight with a government. If a government no, I'm making it. People think that it's politically motivated. That's why I'm saying that it is not. If it is not, it is constitutionally mandated, and that tall order, if the threshold has not been met, there have been several Chief Justices that threshold was not met, and they kept there. I can tell you on authority that previous government, when it even started, the same president, after all this, said that the person should stay. So I'm sure that what ought to be done, the due process will be done. But the decision, it is for her.
I don't understand. The same president, after all this, the petition should stay. Are you saying...
No, when petition was sent. When petitions was sent...
And his head.
When petition was sent, and was sent to Council of State, the president said that, look, with Council of State, I've looked at it. They said, look, you have not met the threshold. Go ahead.
Oh, that's what you mean.
Yes,
you don't
that's what I mean.
There was an end to an investigation.
He said, look, let's
okay,
go ahead
thank you.
and do
Yes,
your work.
yes,
right?
Bafo. Yeah,
brother. We need to tread cautiously. We need to tread cautiously.
Should she jump?
I don't think she should. She has to stay. She has to fight on. Look, it shouldn't be easy for a president or anybody to go after a chief justice. It shouldn't. Otherwise, we would have failed in this constitutional democracy enterprise. The judiciary is all we have between ourselves and the executive and the legislature. Look, let me say this. Politicians, we can always seek after our interests. Right? And so the citizens should not sit back and watch us or and make things easy for us. Especially when it comes to things involving institutions, constitutional institutions, or democratic institutions. Look, how many political cases are determined by a court? They are less than 5%.
Right. Yeah. But they are the important things to the politicians.
And so I am even, you see, let me tell you today that lawyers in Ghana surprise me. We are businessmen first and foremost. Apart from being professionals, we are also businessmen. How often do we go to bar conferences and even evaluate the business that we do in our courtroom, the challenges we have in our courtroom? How often? Every business takes stock. And so as an association, we should be taking stock. The people that should be taking interest in the affairs of the judiciary is the Bar Association. Right? What are the challenges we face in our day-to-day business in our courtroom? But we are allowing the politicians who have about 5% or less than 5% of the business, right, dictating things. We should have a greater stake in it.
They say your associations are hijacked by the politicians.
Because you wouldn't take interest in it, or if you do, someone else wouldn't. We think that we should practice in silos.
What you just said, somebody's going to accuse me of something, right?
You know, we practice in silos.
Okay.
So she shouldn't jump. She should stay there and defend her oath.
Okay. Let me read a couple of messages and then we take a break. And then when we return, we find out if indeed Ghana is a crime scene. Kofi Bentil says that Article 146 is clearly inadequate. We need a statute to iron out procedures for activating this article, or we need to amend it. Meanwhile, all the discretions exercised by the president under Article 146 are subject to Article 296. The president should publish the processes. Whoa. I thought that was a caveat. Okay. So he refers to Article 296, which says that the exercise of discretionary, power must be fair, must be candid, must not be with resentment, either by, personal dislike and so on and so forth. It must not be prejudiced. All right. So sharing with you some of your messages. This one says that though I pray Madam CJ is not removed, it's a Cat-22 situation. The NDC will forever label the Supreme Court as a unanimous FC if she stays. If she goes, they will accept the judgments of the Supreme Court, even if it doesn't go in their favor. Frank Anderson Jr. says, as a grandson of an uneducated fisherman, it is either the law which determines the process. So it's either the law is badly written, or we just love needless arguments. If the Constitution wanted presidents to first contact CJ upon receipt of a petition, it would have clearly stated so. Knowing Ghanaians very well, if Mahama had reached out to CJ outside the constitutional provisions, can we imagine what these same people would say? Still, we love Ghana by default. Samuel Brian Boabin says that there are many ways to kill a cat. Agenda part 2 is in play. The coincidence in events are so numerous that they appear deliberate. They are determined to remove the Chief Justice, just as they attempted with Georgina Wood, an effort that failed because some individuals deemed it unwise to pursue such an agenda. Only God can save the Chief Justice because this is a campaign promise. Oh, I see. Interesting comments there. Musa Abatua says that, Musa Abatua, so I say, it's deeply troubling, Samson, to see such a glaring inconsistency in the arguments being made. It's one thing to advocate for due process and fairness, but to suggest that a prima facie determination should be made for the EC boss without hearing her, while simultaneously calling for the Chief Justice to be given a hearing before such a determination is made, reeks of hypocrisy. Both individuals are under Article 71, yet a different standard is being applied in each case. Professor Kweku Azar, Tadio Sorry should write extensively on this matter. The law is clear. Article 146 doesn't create exceptions based on the office or the individual involved. President Mahama's decision to forward the petition to the Council of State is perfectly lawful. This selective application of the principles undermines trust in the legal process and is, frankly, a disservice to the integrity of the system. Okay. You wrote in Chi. Sorry, I'm unable to read that quickly in Chi. It will take me a little time to think about it. Nana Akwamwa Boateng, Ablekuma Central, you say today's panel is super fantastic. I'm learning so much from today's program. Kudos. Thank you for that. This one says, okay, we need to be careful not to read words into the Constitution when those words don't exist. The procedure for the removal of the CJ is clearly laid out in the Constitution. Well, the law is that the Supreme Court fills in gaps when there are gaps. So you must take that into consideration as well. And this is from Perry, saying that the Council of State has prominent statesmen and women capable of making a determination of a prima facie case. That is undoubted. Thank you very much. Wisdom says, in my respectful view, the bringer of the petition, whether or not rented, may not be as material as the content or substance of the petition. We pray our judges hold themselves in a manner that politicians will not be successful with toying with the judiciary. I subscribe to that. Why is everybody talking as if this is a legal constitutional matter? Yes, the process is written in the Constitution, but like in the Charlotte Osei case and definitely in the Tokonu case, this is purely a political decision. The Constitution is just an excuse, a very good cover for executing a partisan decision, pitching her against the president. No amount of legal strategy and maneuvering will save the Chief Justice. This is from Nekwe. This is from Nekwe. Okay. Okay, so I think enough messages now. Can I take a break so that you don't... Those of you with more messages, please forgive me. I think this is all I can do for now. We'll be right back.